We ready to proceed? Okay. Well, welcome to this meeting of the Board of Adjustments. Today, thanks you for being here. This may be the largest crowd we've ever seen here at the Board of Adjustments for some years, so thank you for everyone who's interested in this issue and being a part of this. We're going to proceed here today. We first begin with a word of prayer, which will be offered by Barbara Smith. Thereafter, if we could rise and repeat the Pledge of Allegiance, which will be led by Wes Marriott.
Our dear Father in heaven, we are so grateful to be citizens of a nation that is free. We are thankful that there is due process in all things in this country. And we are grateful today to be gathered as citizens of Provo, Utah, and we are thankful for the people who carrying off to participate in this process. Please bless us this evening that we will remain civil in our dialogue, that we will communicate effectively, and that correct decisions will be made. And I say these things humbly in the name of Jesus Christ. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Before we begin the proceedings today by reading the item into the record, we want to make it clear that if the manner doesn't go your way as you feel today, there's always the possibility to appeal this decision to the 4th District Court within 30 days by filing, 30 days of the filing decision of the Board of Adjustments. So with that being said, we're going to move to item number 2 of the hearing. I believe item 1 has been withdrawn. Is that still the case? We're not dealing with item 1?
Yes.
So we'll move to item 2. Which states, Paul Evans requests an appeal of an administrative decision to the Board of Adjustments for the Blue Rock Medical Group sign located at 3152 North University Avenue in the professional zone, Riverside neighborhood. Brian Maxfield with Provo City is the staff member in charge, and we will first give him the opportunity to speak.
Thank you. This appeal regarding the Blue Rock Medical Group sign can actually be broken down into 2 parts. The first is an appeal of the building permit, which was issued, and then the second is an appeal of an indemnification agreement reached between the city and the applicant, which dealt with the utility line on site. As much as this is a big impact on the community. There's a lot of emotion involved with it, the appeal of the sign. It really breaks down into the jurisdiction that the board would have in reviewing this. And staff's review in section 1405, which deals with the Board of Adjustment and the zoning ordinance, it states that all appeals and applications made to the board shall be in writing on forms prescribed by the board and within 14 days of the action or decision appealed from by filing a notice of appeal. And continues there, but the important part is the 14 days. The permit was originally issued in October. Visible construction was in mid-December, and the appeal was filed mid-February. And so we believe that it does not meet that 14-day standard. Second is appeal of indemnification. Is agreement between the basically the city and the applicant for something on their site really is not part of section 14 and part of the purview of the Board of Adjustment. In the 140503 states that only decisions applying this title may be appealed to the Board of Adjustment. There's also reference in some of the applicants' letters to an earlier agreement between the city and the applicant, a court settlement, that also would be outside the purview of the Board of Adjustment. For those reasons, staff has recommended that the Board of Adjustment dismiss the appeal based on the lack of jurisdiction of the board and regarding the indemnification agreement and the untimely filing of the appeal.
Thank you. Any questions for staff at the present time? Okay, Brian, if it's okay, we may come back to you. Can you just hang tight? That would be great. Is the applicant here as well? Mr. Evans? We'll turn some time over to you if it's okay, if you want to come up to the lectern, and feel free to provide us your presentation. After you're done, what we'll probably do is we will ask you some questions after you have completed your presentation and questions have been asked and answered. We'll turn some time over to the public and allow them to speak as well. Mr. Evans, have these been provided to Provo City as well? Have they had a chance to review these?
The yellow and blue ones, yes. The green one is just a preview of the slides.
Perfect, thank you.
Could you go to full screen on the slide, please? Down in the bottom right, there's a little... No, there we go.
Slideshow. Go over to the left.
So we elect our mayor and municipal council, and they in turn act in our collective best interest. The expectation we have generally is that our best interests will be advanced within the parameters of our legally enacted laws. In this appeal before you tonight, while the best interests of Provo City may have been a focus of the Provo City administration, the Provo City administration has repeatedly violated our ordinances and acted outside of the law. The North University Avenue citizens, who I'm just one member of and who filed the appeal, so it's not an individual appeal, it's the North University Avenue citizens, appeal the Provo City administration approval of the building permit plan for the sign at Blue Rock Medical Center located at 3152 North University Avenue in Provo, and the Title 14 related issues in the indemnification agreement between Provo City and Wendell Gibby for the Blue Rock Medical Center, LLC, both of which occurred, and let me just emphasize this, the indemnification agreement and the building permit plan were both approved by Provo City on the 7th of February, 2019. We submitted our appeal on the 14th of February. That's within the 14-day time period. The approval of that building plan was illegal, directly violating sign regulations in the North University Avenue River Bottoms Design Review Corridor sign ordinances that are in Title 14. That's under your purview. This appeal is correctly before you this evening as both timely, we filed it on the 14th of February within the 14-day window, and the venue is correct as the Board of Adjustment is specifically empowered to remedy errors in the requirements, decisions, and determinations of Provo City administration in the administration and interpretation of provisions in the Provo City Code, Title 14. So in both the building plan and in the indemnification agreement, there are items of Title 14 interpretation and administration for which we appeal. The Board of Adjustment is the quasi-judicial body that is designed to correct specific errors in this administration and interpretation of provisions in the Provo City Code, Title 14, which we call the zoning ordinances. I think the errors and the problems for which we request remedy are best stated by Provo City Mayor Michelle Kafusi in her blog post on 8 February 2019, which is shown here on the screen. The bold is my emphasis. The sign is inconsistent with the North University Avenue River Bottoms Design Review Corridor included in the city's land use ordinances. The reaction from citizens made aware of the sign has been almost uniformly negative and with a high degree of intensity. I can't say I disagree with their feelings. The mayor then goes on in her blog to explain how and why this sign came about. But it's these inconsistencies that we appeal. Again, we applaud our elected officials, mostly, in attempts to protect our best interests in this case. However, in this particular instance, the Provo City Administration has repeatedly acted outside of the law. The Provo City Administration has repeatedly acted in an arbitrary and capricious manner, creating new sign standards and interpretations for just one property and one property owner, in contradiction to existing Provo City Code. The Provo City Administration is not enforcing existing law and is not even enforcing the illegal standards that were penned to a settlement agreement or an indemnification agreement, all whilst trying to do the right thing. In this case, the right thing is so very wrong and illegal. Next slide, please. So just to put this in a little bit more detail, on Thursday, the 7th of February, 2019, two events occurred. First, Provo City and Wendell Gibby for Blue Rock Medical LLC finalized an indemnification agreement. The project had been on a stop work order or red tag due to some issues, and the indemnification agreement resolved some of those utility issues that were present at the location. Secondly, on this day, the Provo City Building Department approved the building permit revision E for the sign at Blue Rock in the North University Avenue River Bottoms Design Review Corridor at 3152 North University Avenue. I provided for you in your packet this building permit plan that was approved. It was only discovered that it was present on Monday of this week. We had asked for copies of things before. It was provided, but the building plan had not yet been entered into the system on February 6th. And so it was unavailable to the city in general as an approved plan. It was on February 7th that the plan was approved and stamped by building department, by the chief building engineer for Provo City. At the time, the construction on the site at Blue Rock Medical consisted of an excavated foundation. The forms had been set for concrete. No concrete had been poured yet, and rebar had been installed. So when a building permit is issued, the applicant has the opportunity to proceed, but always with the risk that within 14 days, someone may appeal it, and you don't know if that appeal will or will not stick. So if we go to the next slide, this is the indemnification agreement, and I just point here to recital B, where it states that Blue Rock submitted an application for a signed building permit that did not match the dimensions agreed to in the settlement agreement. And this will be a consistent point all the way through our appeal, that first of all, the settlement agreement was not legal in terms of setting a new sign standard that was not promulgated by legislative action. And then secondly, even if that was to hold, Provo City is still not following the standards they set in that settlement agreement in terms of the dimensions of the sign. Next slide, please. So the indemnification agreement was signed by Provo City and Wendell Gibby on the 7th of February. Also on the 7th of February, you can see that revision E of the approved plan for the building of the sign at Blue Rock Medical Center was approved by Provo City Building Department, by DF, who is the chief building inspector for Provo City. This if this is version E, then there have been at least 3 previous versions that Provo City has had a chance to correctly interpret the zoning ordinance with regards to sign dimensions in the North University Avenue River Bottoms Design Review Corridor. But this is the 5th version that is present. We're aware of two others and not certain about all five of them, but we are aware of this one. And again, this was discovered on Monday of this week. So our appeal is timely. It's within the 14 days, and we're appealing this particular plan. In fact, we've been following the idea of what is the plan that was to be, for the sign that was to be built at the site. If you review the documents that we've provided for you, that discussion has been going on for, over a month. And we go, well, we'd get different versions, different ideas. This is the current version. This is the version that we appeal. You can see that the height of the sign, which is not drawn to scale, that's kind of an interesting issue for plans submitted and approved by Provo City Building, has a 5-foot foundation that is above the grade of the sidewalk along the frontage of the building. There's also a 2.75-foot set of columns on top of that foundation, then 13 feet of a sign structure, and then 2 feet of the top part, making the sign in total 23 feet tall. The width that's shown there across the top is 19 feet 4 inches, so 19.25 feet. The Provo City Code for signs in the North University Avenue, River Bottoms Design Review Corridor state that freestanding signs, monument signs, are to be 10 feet high above the sidewalk grade that front the property and a total of 60 square feet in size. So we find that we have both standing and timeliness with regards to this particular sign that is under construction. Next slide, please. So on the 14th of February, the North University Avenue citizens submitted an appeal on the issue of the size and height of the sign. That was within the 14-day appeal. We also specifically, in the appeal, stated that ordinance states that an appeal stays all proceedings in furtherance of the action appealed. So at the time, we had a foundation, concrete had been poured, and the rebar sticking out, no other structure at the time that we filed the appeal. Since that time, the applicant has proceeded with the construction of the sign, whether or not that's in contradiction or in absence of any knowledge to what Provo City may have said is unknown to us as in this appeal. So again, just a reminder that any further construction on a project while it's under appeal is at the risk of the owner. Next slide, please. So today we're here because the evidence that we provide to you directly shows that the Blue Rock Medical Center sign is illegal with respect to height and size area regulations, violating Provo City Code Title 14, and specifically the two subsections there that deal with height and area of the sign. Provo City administration has illegally and with compounding errors replaced Provo City Code with arbitrary and capricious sign regulations. I say arbitrary and capricious, meaning that there's no basis for understanding how those sign regulations were arrived at. There's no public knowledge of that. And that Provo City administration has erred in the application and the interpretation of Provo City Code Title 14. Next slide, please. So, we're here to appeal, to ask the Board of Adjustment to require Provo City to obey Provo City Code and to require that the sign at Blue Rock meet the size, area, and height standards of Provo City Code. Thank you.
Thank you, Mr. Evans. Great presentation. Before Mr. Evans sits down, do you have any questions for him?
Yeah. I just wanted to know, and just more out of curiosity and information, but why didn't you appeal on the revision A?
Because we didn't know about Revision A. Revision A was filed on the 24th of October. No noticeable construction began on the site until the middle of December.
So you're saying you didn't, like, it was filed, but you're not sitting there looking through
There's
all
no
the
public
yeah.
notice of that, and then we began the analysis of what was there. We realized that the window for that version as of the 15th of December had passed, but when we found that there was an indemnification agreement that stated, hey, you submitted a building permit that contradicts or is larger in size than what we agreed to in the settlement agreement. And it's like, well, okay, Provo City, somewhere you have to obey whatever standard is that you've put forward. Mm-hmm. And so that was one arm of the appeal that's before you. Certainly the discovery on Monday that version E of the building permit had been approved on the 7th of February opens the entire door.
Yeah, so follow-up question to that about if the door is open on February 7th with this indemnification agreement, why not file something when the settlement agreement was entered? Because clearly that's public and can be obtained when the settlement agreement was entered back in July and August. I want to preface that because I want to give Provo City staff the opportunity to respond to that argument as well. So let's hear your response, and I want to hear what Brian
So
has to say.
the presence of a suit by Wendell Gibby and Blue Rock Medical Center against Provo City was filed in October of 2016. Okay, that's when the lawsuit was filed. In that time, from 2016 up until the middle of December, I don't know of anybody outside of Provo City administration who was, and possibly the municipal council, who was aware that a suit had been filed or that a settlement agreement had been reached. The only way to know that a settlement agreement had been reached was first to know that a suit existed, second, to find the case number and go down to the 4th District Court and look up and see what paperwork has been filed with regard to that case. We did that subsequently and after finding out in mid-December what had happened, but unfortunately, or in reality, nobody is there regularly checking the court filings as to the status of material.
Yeah. Brian, what's your response to that the door was opened on February 7th?
Well, there are two things again here. One would be with the building permit and to when that was issued. The permit was still issued there. It was discoverable in mid-December. The change on February 7th was merely to recognize the indemnification of those utility lines that are shown on that plan. The sign did not change. It was the illustration of those utility lines and making sure there was an understanding that if the city had to come in and replace that or fix something and we damaged the sign, it's not our fault, basically. And so, that still was discoverable in December. And so we would contend, we get corrections all the time. When the mall was built, there were changes made through the process. And those are reflected on plans and approved. That doesn't then backdate or foredate the permit up to that time. The permit was issued back in the original issuance date. There are changes that occur.
Just to follow up on that, you said it was discoverable mid-December.
Mm-hmm.
So do you know when that date was? I mean, a reasonable amount of time to file an appeal and everything.
I can answer that.
Why don't you tell us your name?
Marcus Draper. I'm an attorney for Provo City. So December 15th was the day that construction began, and it was visible construction, and Mr. Evans had actual notice as of December 16th. So that construction had began. And then this Utah Supreme Court indicates in Fox versus Park City that once construction begins, a person's on notice that a building permit has been issued.
So at that point,
The
though,
14-day clock runs on December 15th because that's when the construction began.
okay.
All right, to clarify, we both have button issues. If it is an indemnification that they're appealing, then this board does not have jurisdiction over an indemnification.
That's correct. Let me explain a little bit about the fact scenario there. During construction of the sign, they are digging to place in the footings for the sign. And they came very close, and it is our belief that they may have actually struck our water lines. So as a result of that, Public Works put a stop work order on that, and that's a Title 15 issue, not a Title 14 issue of Provo City Code. So outside the purview of the Board of Adjustment. That stop work issue was resolved with the indemnification agreement, whereas they agreed to indemnify any damage to our water line, any damaging resulting from a failed water line that may have occurred as a result of their construction of the sign. It doesn't relate to permitting them to build the sign other than to resolve the proximity to the water line.
Were you aware of the fact that once it starts, you had a 14-day window, that once it starts, or did you think that the window was already closed on the 25th to whatever?
Sure. The window is on the plan and the building permit that is on the table at the time. And certainly when we submitted the appeal, it was without the knowledge of the change in the building sign size that occurred as evidenced by the 7th February building plan that was approved. So although it was just stated that the building size did not change, if you will look at your files, you will notice that one of the files shows the building plan that was provided to the North University Avenue citizens that was dated for the 27th of November. In that plan, the foundation is shown to be 2 feet above grade. In the plan that was approved on the 7th of February, there's a change in the dimension of the sign, increasing that foundation to 5 feet above grade.
Yeah,
So it's
I understand where you're
a substantial change in the size of the sign, and that opens that issue.
And I think if we could give Provo City just one opportunity to respond to that, because I think we're all interested in that in this room about Mr. Evans has made a claim that Provo City is not enforcing its existing laws, which I think was what he's alluding to here properly. Would you like to respond, or?
Yes, if I understand correctly. So in August, we entered into a settlement agreement to resolve our dispute with Mr. Gibby over whether or not the Provo City Code in fact permitted him to build this sign. So what Mr. Evans is suggesting is that he has the opportunity to appeal to this board the administrative executive decision of the mayor to resolve legal disputes, which on uncertain areas of the law that have not been interpreted by Utah courts. So I would argue that that is outside the jurisdiction of the Board of Adjustment to interpret the mayor's authority to resolve legal disputes regarding Title 14 or otherwise when those disputes are not settled law in Utah. I think it's reasonable for the mayor to resolve that dispute. As to any differences that may be between the dimensions of the listed in the settlement agreement as what was approved in the permits, the footings that there's no description of how far above grade in the settlement agreement. There's a size of the sign. There's the footings, which are a natural part of building a sign of that size, are not listed in the settlement agreement, but were understood that you'd have to have footings to build the sign. So that is not a breach of the settlement agreement, and certainly not outside of Provo City law to build footings when you need to build footings to build a sign that you did agree upon. Any changes in dimensions from the settlement agreement versus what was approved in the permitting, certainly could raise a breach of contract issue, but again, is not an application of Title 14. Those permits were approved. There was very minor differences between what was in the settlement agreement and what was ultimately approved that would make the sign only slightly larger and it would not be noticeable to a person driving down University Avenue that this is, 18 feet versus 18 feet 6 inches. For example, I'm not pulling the exact numbers. I'm just hypothetically speaking there. So, in any event, those issues were approved in October when the building permit was approved, and any subsequent modifications were all approved in December. So, and construction began December 15th. At that point, the 14-day clock began running because he was on constructive notice that the permit had been issued. As was previously stated, the only thing changed was, in fact, the recognition of the indemnification issue on the water lines, not the dimensions of the sign from the December issuance of the.
Yeah, thank you. Thank you.
Just one slight thing with that revision D and asking where's A, B, C. That's just the revision from the engineer or architect of the owner. It doesn't necessarily mean all of those get submitted to the city because they may be, it's just the name of that version for their tracking purposes. That plan actually was received by the city in December 11th, and version E, and inspection for footings were done pursuant to that plan and approved in December. Then the stop work order was placed on it, and unfortunately, they didn't get around to marking it approved in the file until February. But that is the version that the city used to do inspections in December.
Question, Gary. Go ahead.
Well, yeah, with that lack of putting into the system, would that give, in your opinion, a different type of understanding towards the citizens who are appealing?
No, state law, the Supreme Court has ruled that the time begins to run on your ability to appeal when construction begins. So an appeal should have, once construction begins in December, the time clock has 14 days. In addition...
but he should know what that is, right? And if it's not submitted in the system, he doesn't know, right? So does that... Well, that changes why he might appeal, right? Because he doesn't see and it's in the system, and so he's like, am I going to appeal this or no? I don't know. Now I will because it looks different than what they agreed upon, right? So it changes why somebody might appeal.
Yeah, there's that issue. There's also the issue of here's an example for you. The city has a 20-foot setback requirement for single-family homes, your front yard. And the city issues a permit for a construction of a wheelchair ramp in the front yard. And construction begins. And neighbors come in and say, well, hold it, you can't construct in the front yard. We don't like that. It violates your code. Well, the permit was issued pursuant to federal law dealing with reasonable accommodations for people with disabilities. And in this case, the permit was issued pursuant to a resolution of a legal dispute over what the ordinance means and what it allows. And so the authority under which the city's doing it is not Title 14. It's resolving a legal dispute to the very nature of what do these ordinances mean.
But it does violate city code.
That's what the dispute is about. Does it violate city code?
That was the essence of the dispute, and the determination was to resolve that dispute rather than litigate it to the full extent. If Mr. Evans were allowed to appeal that settlement agreement and the building of the sign, then that would essentially say the city cannot resolve legal disputes regarding Title 14 without being subject to appeal to the Board of Adjustment. I think that would work an absurd result.
Thank you.
I'd be happy to respond.
Take a minute, yes.
Thank you so much. The height of the signs in the North University Avenue Design Review Corridor is an essential component of what the neighborhood and citizens have been working on for decades. The height is 10 feet. Now, from what baseline is that height measured? And the answer is the height of signs in ordinance are measured from the grade of the sidewalk on the frontage of that property along University Avenue. So in the settlement agreement, there was no discussion about footings, as the city has rightfully stated. But the height of the sign is indicated as 17 and a half feet high. Measured from what? Title 14 states that the height of signs in the North University Avenue's River Bottoms Design Review Corridor will be measured from the grade of the sidewalk frontage. So we now have a situation in which Provo City administration has been making new and different decisions about how to interpret and carry out Title 14 with regards to the height of signs. We have 3 versions of the plan for the sign that have been provided by Provo City. One version is dated, was approved on the 15th of October of 2018, with the building permit issued on the 24th of October. A second version of the sign that Provo City provided through grandma request was a version of the sign dated 27th of November of 2018. In the 27 November version, the footings are 2 feet tall. You'll notice that in our request for an appeal to the Board of Adjustment, we state that the footings that are being built are in violation of the 27 November building plan that was provided to us. So now we find out that the 27 November building plan is not current, but rather it's a 7 February 2019 building plan, which does show a 5-foot footing. However, the height of signs is not measured from the top of the footing, it's measured from the grade of the sidewalk. In this case, the grade of the sidewalk and the grade of the pavement for the Blue Rock Medical Center is approximately the same at that location. So you'll see on the building plans curbs that are shown on the left-hand side indicating the east side of the property, or the east side of the property where there is a building permit. So indeed, the height of the sign and the interpretation of what that sign height should be is totally before you as a change that has occurred uniquely in the 7 February 2019 building plan that was approved. I find it ironic that the Provo City would argue that the stamping or the formal documentation of a building plan, even though it didn't occur till February 7th, is somehow still equally effective as some unknown previous date. And I'm just going, whatever standard we use for windows, it must be the same for the applicant as well as the city.
Yeah, and I think what we're trying to figure out here, I mean, obviously you've made a very good case of it's against, city code of what is put forth. What we're trying to figure out, the three of us have to decide, is if we have jurisdiction to make the appeal. And do you feel that, like, based on your understanding of what the project is and what it was with the footings and everything, your understanding is that you made the appeal as soon as you could have, or whenever your understanding of what that sign was? Do you feel like that was within that jurisdiction or within that time frame? Like, we're trying to figure out why on the 15th of December or 16th, when you found out about it, you didn't file an appeal then. Is it based on some of the footing that was just approved in the revision E that is changing some of that thought process and why you have appealed at that point.
Sure.
Just trying to figure out, because what we have to figure out is the jurisdiction that we have on this case. Whether we agree with you or not about what it is, we have to figure out if we
Right.
fall within that.
So I'd like to focus on from 7th February to today, okay? And just stay focused on that for just a moment. And it was then that we knew that an indemnification agreement had been reached. There had been discussions with Provo City administration and the mayor prior to that. There was some discussion that there would be something worked out. But then on the 7th of February, communication from Mayor Kafusi said, we're going to go forward with a sign as it's currently allowed. So why didn't we do it earlier? Because we had discussion with the administration that perhaps there was going to be some way of working this out. The indemnification agreement, again, specifically states that the sign as submitted by the applicant is not consistent with the dimensions agreed to in the settlement agreement. We didn't have an absolute statement from the administration saying that they would not follow their rules that they had illegally put together in terms of the sign size in the settlement agreement until that indemnification agreement is in there. And as pointed out, it states, even though the sign does not meet the dimensions, we're not going to do anything about it, for which we appealed to the Board of Adjustment. Ask Provo City to enforce their own Title 14 ordinances. Second, the height of the sign is incredibly important. It's one of the two major parameters that impact the signage along University Avenue. The best information that we had, based on a grammar request from the city, was that the footings would be 2 feet tall. Then, on the 7th of February, Provo City approves a plan in which the footings are now 5 feet tall. That increases the sign not by inches, but by feet. And yes, any reasonable person driving along there will notice the difference between something that is 20 feet tall versus 23 feet tall. So, this is the first opportunity we have to say it was incorrect for Provo City to approve a plan on the 7th of February, which violates Title 14 with regards to the height. And fundamental to that is the presumption of from what baseline to measure the height. And our argument is that Provo City errs in measuring the height from the top of the foundation. The only ordinance we have in place is Title 14, and in those subsections where it states that the height will be measured from the grade of the sidewalk. In this, Provo City has erred in the application of Title 14.
I just have one follow-up question too. Isn't your argument also that they erred back when they issued the building permit in December and they started building in December as well? Aren't you arguing as well that that Provo City somehow breached or violated their duties at that time as well?
That would be, that is an absolutely correct statement, that they did err with that in December. And what's really interesting is that they entertained revisions of the height of the sign from October through February. And there were different versions of the sign height and location and everything else. And at any point along the way, Provo City could have said, we have made a mistake and the sign is illegal. We cannot proceed with this. And they had the opportunity to do that even after public discussion in the middle of December. They knew that there was a problem. Because that's the first time the public knew that there was an issue.
Yeah. Thank you. Any further questions for the applicant? Thank you, Mr. Evans.
Actually, just maybe one more, just to follow up. When you found out about this on December 16th,
Yes.
what did you know about the project, and obviously, what were your feelings about it at the time, and what were some of the, I don't know, the reasons why? I mean, it sounds like from the 16th or from the 15th, you were already disapproving of the project, or maybe you didn't think about it that much, or maybe, you know, whatever, like, the reasoning behind the missed window might help us a little bit.
Sure. So this is a very, just based on the documents that I've sent you, I think there's 30 of them now, and it has to be on a CD that it doesn't fit in email. Okay, I apologize.
Biggest we've ever
but it's
gotten.
taken a while to work through exactly what happened and when, so that you know how to respond. So for example, when I first asked Provo City, how could you approve this sign of this size in the North University Avenue design corridor, the response I got from Provo City was the code for the SC3 zone. Well, that's the shops at Riverwoods further north on there. And so I go, well, why am I being sent code, justification for a sign in a property that is zoned professional office? So then you have to kind of work through all that. And frankly, it took time. We're volunteer citizens, and to try to sort through all the documents and really tease apart what it is that could be done. In retrospect, sure, file the appeal right away. I asked Provo City, hey, what do I need to do to appeal this? I should have followed up more on that, but we have the February 7th events, without regard to, that state clearly, here are the changes that occurred, and both the interpretation of Title 14 as evidenced by statements in the indemnification agreement, as well as the factual 7th of February 2019 building permit plan that's marked as approved.
Thanks.
I have a question for Provo City at this point. So if changes were made to the sign in the plans in the middle of an indemnification agreement, does that reopen our jurisdiction on this?
That's not what occurred, first of all. Okay, I just want to make that clear. The changes that were made were all made in December prior to the start of construction. Okay? The changes that were made...
But it was mentioned by Gary that it wasn't filed until the 7th, correct?
The changes that were entered in that version were simply, again, did not reflect what he's talking about the footings. The footings were in the original permit that was issued in October. So he was aware. What he's referencing is the settlement agreement, which did not have the footings at all. Okay, so I would speak to that. That there haven't been any substantive changes to the sign itself that have occurred since December. So I would ask that the audience not interrupt me.
If you're here from the public, you're going to have a chance here in a few minutes to say what you'd like. If you'd please be respectful to those that are speaking at the time, that would be much appreciated. Thank you.
Thank you. Yeah. So I don't believe that the facts match what he is stating. Mr. Evans has been well aware for quite some time about the dimensions of the sign, and that there were some minor changes to the dimensions of the sign, but the footings themselves were not in the settlement agreement, but are an integral part of the sign. And whether or not we could say putting in the footings might be a breach of the settlement agreement or not, the bottom line is it was implicit from approving the sign that there would have to be footings. And so it is a case that ultimately is not one that we are likely to prevail on in court, and it doesn't make sense to sue for breach of contract under those circumstances. And ultimately, plans were approved beginning when the permit was issued, and revisions all the way up to the last inspection, December 11th, as Gary McGinn noted. The construction began 4 days later, and Mr. Evans became aware within the next day. He did make lots of communications with the administration during that time period, However, he never actually appealed the decision to issue the permit. And Utah Supreme Court has said you have 14 days from the start of construction to appeal it. He's not appealing any difference in the size of the footings. If you look on his appeal in this case, he hasn't made that appeal. So if he's trying to, what he's trying to do is say, this was the reason I appealed on February 14th, but I didn't find out about it until March 18th. That doesn't make any sense. It's clearly not the reason that he didn't find out about revision E until Monday by his own statement today. So his argument that he's appealing the change in the size of the footings, I think, is not well taken. So I guess what I'm saying is what he's saying is not matching the actual facts. So if he were actually appealing a permit that was issued on February 7th, sure, that would be timely, but there wasn't a permit issued on February 7th. It was issued on October 24th. That's when the permit was issued. The construction began on December 15th, so he had 14 days from that date to appeal it. And for that reason, his appeal is well untimely. And he's been well aware of the timeliness issue at least since February 6th in a collateral matter that he is pursuing with the Ombudsman Office. He certainly became aware by then that he was untimely with his notice of appeal, and yet he still waited 8 days beyond that date to actually file. The indemnification agreement doesn't restart it. You can't appeal an agreement. His remedy is not to a tribunal. His remedy is political.
I also have a just quick question for you. How much construction has been done so far? And
I have not driven by there recently, so I couldn't tell you what the progress is. My understanding is that there's been substantial construction to this point.
Thank you. Mr. Evans, let's give you the last word on this issue. If you could just respond to his statements, and then pending further questions, we'll move on with the meeting.
Sure. If you'll look at the Board of Adjustment appeal, I specifically state that the height of the foundation that is being built is appealed, and that it violates Title 14. It's in the Board of Appeal. I can look at its item number.
I think 13 and 14.
Yeah, number 13 and number 14. In there, we state that the only other building permit plan that had been provided was from the 27th of November. In that plan, the height of the foundation is 2 feet above the sidewalk grade. And we appeal the fact that Provo City is not holding the builder to those standards. So then we find out, this Monday, that there was a plan that had been approved. In the grandma request that we submitted, it said, here are the 2 plans, this is it. And then when this was discovered, Provo City responded by saying the plan had not been entered into the system, and there's no way that we would have known that it existed. The standard's very clear. It's stamped as approved on the 7th of February. There's no other dates as to when you submit it. The issue is, when was the plan approved formally by Provo City? And in that plan, the foundation is 5 feet tall. That's a 3-foot increase in the size of the sign. And it violates Title 14, in which it states that the height of the sign is not based on the foundation, but based on the grade of the sidewalk. And so in the settlement agreement and subsequently, Provo City has been unable to enforce its own code. And that's what we appeal and ask for your remedy on.
Thank you, Mr. Evans, thank you. We will now proceed forward. We'll give an opportunity. Is the neighborhood sheriff for the Riverside neighborhood, are they present today? Okay, so we won't hear from the neighborhood chair. We will open it up for public comment now, but before we do, could you raise your hand if you plan on making a comment today? Okay, so we have a few. If you could limit your comments just in amount of time and scope, if that's possible, so that we don't have to cut you off, and if you're long-winded, we don't want to do that if we don't have to. But if you'll come up to the, sorry?
Is it at 3 minutes or 2 minutes?
3 minutes, okay. If you'll come up to the lectern and if you'll state your name and then provide what you have to say, that would be greatly appreciated.
My name is Dave Rosen, and I am the neighborhood chair of the River Bottoms neighborhood, which is the northern piece of the University Avenue corridor, just north of the Riverside neighborhood. And I speak on behalf of myself and also Mike Rohn, who is the neighborhood chair of the Riverside neighborhood, who is out of town at the present time. Both of us realize that this is an issue of technicalities. This really originated for the citizens back in the summer when the council approved unanimously not to approve the sign. The mayor subsequently entered into an agreement. We're not asking you whether you have the rights to justify that agreement or overrule that agreement. That was a technicality. When the sign began in the middle of December, residents began to see construction on the site. It did not become evident that this was going to be a sign until much later in the month when they began to pour footings, and we saw that this wasn't a utility project or some other project going on in the area, but was actually a sign being constructed. Again, technicalities. Paul Evans has stated very clearly what the neighborhood's concerns are. As that footings began to go up, we took the plan that was available to us and measured and saw that the footings and the posts were greater than 2 feet above. Thus, the filings began. Again, it's a matter of technicalities. When do the citizens have a right to file a motion when they feel that, and they see that things are being violated? And we will rely on the technicalities as much as the city and anybody else. Thank you.
Thank you, Mr. Rohn.
It's Rose.
Rose.
Rowan's out of town.
Oh, excuse me, Rosen.
Rosen,
Thank you.
yeah.
you have a question?
No, I was just, sorry, my apologies, I got that wrong.
My name is Steve Johnson. I'm a resident in the River Bottoms neighborhood. I actually live across the street from Mr. Rohn. 3 points. A settlement is not a law. Complying with the American with Disabilities Act is a law that has been voted upon and approved and actually has to be done. A settlement cannot violate the law or violate the codes in and of itself. So I find that argument not to be valid, and that analogy or comparison to be totally a red herring and not related. Secondly, 23 feet as opposed to 20 feet is a substantial change, a 15% change in the total height of that. Whether or not, when you say it was approved, but then it wasn't changed, it was changed by 15%, okay? And third, Paul Evans talked to the city and tried to find out what was going on. And from my perception, and only my perception, the city dragged its feet to the point that they could actually stall him out of any timely effort. I don't say this out of malice at the city or not. I just say that's what happened. Paul doesn't shirk things. Paul got on it and tried to find out as much as he could, as soon as he could, and filed as soon as he could after that when he realized what was going on. So technicalities, as Mr. Rohn talked about, use technicalities. Substantial change was approved on February 7th, a 15% change in the height. We're not talking from, not even disputing where you measure from. The plan was changed by 15%. I think that opens it up to your jurisdiction. Thank you.
Thank you, Mr. Johnson.
My name's Dale Anderson. I live in Brooktree, which is just right across the street from where the sign's going on. And would have a lot of residents here, but we've had a little issue and somebody in our neighborhood passed and Mines are elsewhere. Anyway, I don't know a lot about law. I don't know a lot about medicine, but I do know some things about business. So I guess my remarks go out to the public that disapprove of this sign. And that's, you don't start a business that's dependent on the public and irritate that public. So if we want to do something about this and it doesn't go our way with this appeal, then let's not support this business. Use the word of mouth, stay away from it, keep everybody, I know people in our neighborhood are backing it. We will not support this business. That seems like a secondary way to appeal or stop this. Thank you.
Thank you, Mr. Anderson.
My name is Ben Markham. I live in the River Woods neighborhood. I once was the neighborhood chair there. I'm good friends with a number of the city staff that's involved in this. I'm obviously good friends with neighbors also. I hope I'm good friends with them, I think so. It's very frustrating to me as I've been involved, and I didn't get involved till initially about the December time just because I didn't know. And then there seemed to be a veil over things because there was a settlement agreement and this and that. You know, the city didn't seem as forthright as I would have hoped they were being. And when we finally got enough information at a meeting where we talked about things, I became an adamant supporter of the appeal and really appreciate all the work that Mr. Evans has done to do this. I will say that I believe you're doing the right thing in focusing on where your jurisdiction is. I believe there is a case to argue that it does fall in your jurisdiction, what's being appealed. And I will continue to support the appeals that may happen above this. Thank you.
Thank you, Mr. Markham.
For the record, my name is Gary Matthews. I live in the River Bottoms. Back when the design review for the University Avenue corridor was formulated, I was on the Planning Commission. I served on the Planning Commission for 8 years and was there while they designed that design review corridor. And signage like this was not what we had in mind. I worked hard personally to make sure there was enough setback that we would have a beautiful entrance to our city. It's one of the major entrances to the city. And so we have a little better than average setback there in that area, but a lot of signs along there detract from that beautiful entrance to our city. From my understanding is that the property is zoned professional office, and just north of that, I had my own professional office for 15 years in the courtyard at Jamestown Development, which is full of all different kinds of physicians like Dr. Gibby. And in fact, Dr. Gibby was a patient of mine for a long time. I know him quite well. But I don't agree with the sign changing the nature of the entrance to Provo City, and would admonish you to try to use your ability to do what's right, regardless of what technicalities that may have happened. Thank you.
Thank you, Mr. Matthews.
My name is Mary Ann Andrus, and I live in the Pleasant View neighborhood, which isn't directly one of the neighborhoods around this area. But I speak on two concerns. One is aesthetics. I care what Provo City looks like. We have a lot of beautiful areas, but we also have some areas that are not so beautiful, and a lot of that has to do with signage. And when I look at this area, I think this is one of the most beautiful areas in Provo, and what I'm concerned about is the precedent this might set. Now, I don't really think this is rocket science. In fact, there's a young man sitting over here, and I think he probably understands the concept that if you have a law or an ordinance and someone breaks it, there should be a consequence, or you should hold to that law. And if a young juvenile came in here and said, you know, I broke the law, and his parents said, yeah, but we're going to bail him out. We have money and we can do this. You know, we'd be all aghast. We would just wonder what's happened to our system. So I think that issue has been addressed very well about why it's important that a city follow their ordinances and their laws. But aesthetically, what is this precedent going to do? Now, Mr. Gibby probably thinks that if he has a little bit bigger sign, he's going to attract more people. And it's my contention that people find a business in spite of a sign, not because of a sign. And let me tell you why. I went to his business a few years ago. I didn't have any trouble finding it at all, and there was no sign. This last week, I went actually to Dr. Matthews' office, where his son looked at my teeth. And the only thing I can say is I would like to appeal. I don't know if Mr. Gibby is here, but I would like to appeal to his better half to say that, is this really what you want to do with the city? Because what I'm afraid of is if this sets a precedent, then what about other people along there that says, well, maybe we can put up a billboard. Let's have this bigger and higher, and pretty soon it's going to look like Orem State Street. So maybe Mr. Gibby needs to go into Dr. Matthews' office and maybe have some drilling done. Maybe that will help. Thank you.
Thank you. Thank you. Any others? Yes.
I'm not going to get a debate for and against all the things.
Mr. Jeffs, do you mind telling us your
Staff
name, though?
report is correct. The staff report is correct. You can't bootstrap from a permit that was issued in October and try to get an appeal to it in March. You can't do that. And that was a decision that was made with the city council. And the city council appeal goes directly to the courts and has to be done in 30 days. The Board of Adjustment, the staff report correctly states that it is untimely and therefore you don't have jurisdiction. That's what the issue is in this matter, despite all of the words that have been said. Secondly, on the second item, the indemnity agreement, that isn't even covered under the statutes that gives the authority to the Board of Adjustment. That is a different area entirely and had to do with different things. That doesn't bootstrap him up to make it justifiable to consider an appeal that is untimely. The staff report is correct. It is untimely. In both cases, it is, you don't have jurisdiction.
Thank you, Mr. Jeffs.
Pam Jones, a vice chair of the Edgemont neighborhood. Technicalities have already been addressed. The fact is, Provo City dropped the ball from the very beginning when it did not enforce the ordinances that specified dimensions of signs. Mr. Gibby apparently has been pushing and pushing. Provo City has given in too many times, and we find ourselves in a dilemma. The fact is, the sign is illegal according to Provo City Code that has been around a lot longer than this issue. The sign should not be continued. At least it should be made to conform to the code.
Thank you, Ms. Jones.
Members of the board, my name is Douglas Nielsen. I own the 3 retail buildings immediately north of the subject property. I know that the issue before this board right now is jurisdiction, so it's a very narrow issue. I was involved in the in the whole process of developing that design standard years ago. And I started building buildings 35 years ago across the street. So I've been involved in that neighborhood and have been intimately interested in it. And I'm very troubled by this sign and the whole process of how it evolved. But I just have a question or two, because it might touch upon the decision you make tonight regarding jurisdiction. My first question is, do you feel that you're compelled to make your decision on whether or not there's jurisdiction tonight, or can this hearing be continued until that issue is resolved?
The hearing can always be continued.
Yeah.
Yeah.
To make, okay. I'm not fully aware of all the details, so I have a question for council or Mr. Maxfield. Now, from my understanding, the permit on this sign was issued, was that in October? Okay.
Right. Yes.
Okay. And there was a decision after that permit was issued to make changes in the sign, although they're minimal. You can argue they're minimal, you can argue that they're material. When was that decision made? To allow for the 6-inch in the height?
There's some modifications because of the utility lines. I'm trying to think of what
I don't think there were any changes to the sign itself. There were changes to location of the sign on the property.
When was it determined that the width and the height would be changed?
Again, the footings were issued from the get-go, so I would dispute the assertion that that the revision E was the first notice that there were going to be footings in the sign, because that's not accurate. So the permits were issued. The original permit was issued in October. There were some issues that needed to be resolved or greater specificity sought, and ultimately all inspections were approved in December 11th, I believe. And so December 15th, construction began. So the issues in relation to the February 7th revision E reflected some of those understandings that came about as a result of the inspections, I think, but not actually changing anything fundamental about the sign itself.
But the size of the sign.
We'll let you continue.
Yeah, the size of, I'm sorry, okay. The size of the sign, when was it? Was it increased after the permit was issued, or the October issuance?
He submitted plans for the permit, and that were slightly larger than the sign that was approved in the settlement agreement. And I understand the issue with the footings wasn't in the settlement agreement, but footings are an integral part of that sign, and the sign can't be constructed without it. But ultimately, the differences in the size of the sign itself were a matter of inches, and so it was the permits were approved at that time, prior to the start of construction.
In October.
Yeah, in that October-November timeframe, correct.
The increased size was approved when that.
Yes.
Before that permit was issued. What about the size of the footings?
The size of the footings was all part of that process.
So it was all determined. Okay. Yes. That's all I have.
Thank you, Mr. Nelson. Thank you.
My name is Codell Carter, and I have an interest in spurious arguments, one of which is saying that you can change from a 2-foot foundation to a 5-foot foundation, and that makes no substantial change in the nature of the sign. That's ridiculous. Why not say a 10-foot foundation or a 20-foot foundation? We'd have this monster sign sticking way up here that you could see all the way to Orem. If changing from 2 feet to 5 feet is not a substantial change, that's ridiculous. And it seems to me, therefore, that the original agreement has been voided when you make that dramatic a change in the size of the sign.
Thank you, Mr. Carter.
I would note that I did take Professor Carter for philosophy many, many years ago.
Noted.
I would note he gave me A's.
My name's Marcia Friedel, and I am not a resident here, but I am the manager of Riverwoods Urgent Care. And we have been there for 15 years. And we have followed the rules of signs. And Paul can attest to this because we had to fight to keep our sign that is in with limits of size and height. It's unfair to the other businesses in this area who are following the rules to have this ginormous sign. And I don't know if you've seen it. It is huge. It's distracting, and it's really unfair. So I come to you as a business owner that it's unfair. You know, it's just not, you can't allow one person to have a sign that big and then tell everybody else they can't. Thank you.
Thank you, Ms. Friedel.
Hi, my name's Sharon Memmott, and I am the vice chair in the Edgemont neighborhood immediately east of this sign issue. We've been following it as we were given notice, I guess is the best, one of the points that I want to make. This doesn't follow, because of the settlement agreement, doesn't follow the normal process of noticing that neighborhood chairs and different things would have been given. Normally we're sent an email, you need to be made aware of this. The city didn't have to do any of that process, so I'm not sure that we should have to, and I don't know anything about the law, how you make exception for that in the 14-day notification. I did personally come down to Provo City to the Office to Planning or Redevelopment, I'm not sure what it's called, and say, what can we do? I've driven past, I've seen how large this is. It's bigger than what everything else is. And at that moment, I didn't know what the settlement was and what he was allowed to do. But I can see just from what's there, this is going to be large. What can we do? The young woman that I spoke with at your office said, well, you can file an appeal, but the date is the 27th of November. So at this moment, we're past that. It was about the 18th. I'm not sure exactly of the date, but it was as soon as I was given an email to go notice this. You can file an appeal, but it was the 27th of November, so you're technically past those 14 days. Well, I guess I can't do anything. So I didn't file an official appeal because I was past that 14 days. I was not told that there was a December date, that we were not past at that point. Of course, the next week was Christmas and everything shut down tight. So again, I don't know how those dates fall into this 14 days, but between Christmas and New Year's, it was shut down pretty tight down there between people being out of the office and all that. Another point being that if, and I haven't seen it, but if the 27th did say 2 feet on a footing, and I know a few engineers that would agree that if you're building a sign that only needs a 2-foot foundation, none of us probably would have been concerned. It's not going to be a large sign needing a 2-foot foundation. This sign is not going to stand up on a 2-foot foundation. It's going to come down on the first wind that you give it. So if that's what we're talking about, a 2-foot footing, this is a problem. So as has been stated, from 2 feet to 5 foot, that's almost an exponential increase of the sign that would be held by it. So that's when our attention was drawn to this. Again, I don't know when those changes were made to plans. Again, the main reason that I went down when I did in December was because I was told there was a red tag on the project and there were people out there working on the project on that day. I drove past to make sure that I was right. So I asked, again, why are there people out there working? Why I thought they were not allowed to work on this project while it was red tagged. They were out there working. Since this appeal has been filed, just in the short time that we were told, since this appeal was filed, they've continued to work. I thought that that would kind of stop this process while we were going through the process to find out if he had the right to continue. Because one of the arguments that was made to us by the city was, well, he's spent all this money. Well, that's neither here nor there for this problem if he continues while the appeal is filed. So the sign is, and we can get a pretty good idea now what size the sign is because it's up. Those are my concerns.
Thank you.
I'm not sure about the jurisdiction and all that.
Appreciate that.
My name is Barbara Carter, and I'm married to that logic professor back there. There are 3 questions. Who makes the rules? Who has the right to give permission to break the rules? And to whom are those people answerable.
Thank you, Ms. Carter.
My name is Brian Harrison. I've known Dale for a long time. We're friends. I live in the neighborhood. I went to the sign today to look at it. It's gigantic. It's gigantic. It seems to me that as you look at this, and I served on the Planning Commission for several years, as you look at this, you have to say, what is the purpose of these ordinances? Are they to benefit the developer, or are they generally to protect the citizens? And in our case, you look at all the signage up and down University Avenue, Gary Matthews is exactly correct, that there was a great deal of thought given to the standards that were implemented in that corridor. And to allow a person to exceed those by a substantial amount becomes a legal issue. That is it a material variation from the litigation or the agreement signed by the city? Now, maybe the city doesn't want to defend that, but I know a lot of lawyers that would defend the residents' position and fight the city like crazy because they're litigators. They're not afraid to go in and say, this is the right thing. In my opinion, if this sign gets approved, we're going to start looking like Las Vegas, Caesar's Palace, et cetera, et cetera. It's gigantic, and if you see it, you can see how much it varies from what the ordinance allows.
Thank you, Mr. Harrison.
My name is Nona Nibley, and I live in that northern corridor. I think as I've listened to all of this tonight, the biggest disappointment to me of it is that we elect city people, and they set their committees, all to help the people who elected them. And here we are at this point, and at this situation where, as I'm listening, I hear that the city made the mistake in the first place. And as I look at it, I question why we should have to be here. If they couldn't, why can't they correct their own mistake and make it so that we don't have to be in opposition to the people that should be protecting the community? Thank you.
Thank you, Ms. Nibley. Is there any other members of the public that would like to comment?
My name is Dave Sewell. I'm a resident of Provo and a member of the City Council, although I'm not speaking to you as a representative of the city, as a representative of the council, or even as a council member. I'm just speaking to you as a citizen and hoping to share a few facts and a few thoughts that might be helpful. My understanding of the code is that in the river bottoms corridor, and I'm looking at it right now, that freestanding signs, including monument signs, are limited to 10 feet, shall not exceed 10 feet in height above the grade of street frontage sidewalk. My understanding from the code that I'm looking at right now is that the total area of such signs are limited to 60 feet. My understanding is that this ordinance and these specific guidelines have been in place for many years, more than 10 years, much earlier than any application for the Blue Rock Medical Building was made. I worked on a revision to this ordinance several years ago that had to do with other aspects, electronic signs and that, but did not touch this section specifying the maximum height or the maximum area. Is my understanding, or I should say my recollection, and at my age sometimes my recollection is faulty, but my recollection is that the owner of Blue Rock Medical came to the City Council and requested a change in the ordinance
so that some of these provisions would be more to his liking several years ago, I think, and that request was voted down, I believe, unanimously, is my recollection. And that at some point after that, the lawsuit, which is now publicly known, occurred, and the settlement and so forth. I don't want to comment on that. I don't want to comment on your responsibilities or jurisdiction or any of those matters. I do want to share one other thought, and this is just a personal sort of feeling about it. I attended a meeting earlier this week with some of our citizens in regard to the sign, and there were some business owners there, including Mr. Nielsen, who you just heard from. And the question was, questions were raised as to how come the city's not enforcing the ordinance. And several of the owners, may I
Please
just
continue. Yeah.
One more minute, thank you. Several of the business owners expressed the feeling that we'd like you to enforce the ordinance, or if you're not going to, we would like to have similar signage because our signage will now be inadequate by comparison. And I just wanted to express the feeling that was one of the saddest nights I've ever had as a council member. To find myself in the position that we're in, where a citizen who decided to sue the city can have a sign that is different than other business owners who chose not to. And I just want to, in answer to the comment, who are the decision makers answerable to? We're answerable to you as elected officials. And my last comment is that any involvement I may have had that led to us getting in this situation, I deeply regret. Those are mine.
Thank you, Mr. Sewell. Thank you. Is there any other members of the public that would like to address this issue? Okay, we'll close this section of the meeting for public comment, and now we'll have discussion amongst the board.
All right. Well, these are my thoughts on it. Obviously, my first thought was when I saw the city's reaction to it, because I knew this was a big thing, my heart kind of fell because I was like, oh, it's not within the jurisdiction. And then my second thought was, well, why is it coming to us anyway? And then I thought, well, that means it's still open for interpretation and understanding of the situation. There's a few unique things about this that I've kind of figured out, and maybe you guys feel differently, but this was a settlement, so it's a different case. The notification is different. The notifying the citizens is different. Their timeliness to respond is different because it's not through, I mean, if the city council had approved it, then it would be a different notification process. Since it was a settlement, most of the people in this room probably didn't even know what was happening. The second thing that they didn't submit the document in a timely manner in the system. I think that is an important piece that people need to know what they're appealing against, and if the city failed to do that, then there's a problem there. Also, just hearing all of you and hearing Paul's testimony and everything about it, it sounds like you did everything in your power to figure this out. And as Ms. Mehmet had mentioned, she even came to the city and talked about it, but they gave misinformation about the timeliness of it, saying that it was probably without the jurisdiction already, and so it was pointless to file, but in truth, it may not have been. Also, I just feel like we're not all experts. If we were all Gary McGinn over here, and he had the same feelings you guys did about this situation, he would have known exactly what to do. The first time he sees the sign going up, he would have filed the appeal. He would have done everything in perfect order. He would have known everything what to do. We don't expect ourselves nor the citizens of Provo to understand every little thing and to be perfectly informed and perfectly just looking through every little document. And in my opinion, government is built on this community, and we can obviously see that the people, had you been experts on the situation, you would have filed immediately to at least ask for the appeal. And also, I mean, us three, we had to look through all of Paul's files, which was like, I didn't do anything all week. No, I'm just joking. But just understanding that it's not an easy process to figure out, file, and go through that, especially during the Christmas season. I think there's a lot of unique things in this, and so I'm in support of Paul in this. As far as the indemnification, I agree that we don't have jurisdiction on that. But as far as the appeal to the building permit, we have the jurisdiction because of the interpretation of what I've said. So those are my thoughts.
Barbara, any thoughts from you?
I am of the opinion that while I would like this to be in my jurisdiction, that it is likely not in my jurisdiction. I do not believe that based on the laws set forth, the policy set forth, on the timing of the filing of appeals, that we have power on this particular issue. I honestly wish that we did, but I think because of the way things are already established, that for us to rule on this would set another precedent. So I do not concur with you. I believe that this is outside of our jurisdiction. I am happy to look at this further. I am happy to table this issue until we have that cleared up. But as it stands right now, I don't think that we can rule on this. And that's my thought.
Thanks, Barbara. Let me just say a few things, and I think I have a couple questions for both of you, but we're just like you. We're not elected. We were actually asked to sit on the board at some point in time in our lives, and so we're here doing what all of you could do as well. So it's an unpaid position, although we do get dinner. Thank you, Provo City, on occasion. Sometimes it's cold, but it's okay. So we're here. We try our best, and we don't always do the right thing. In fact, we have 3 or 4 other board members who couldn't be here today, and it would be nice to have them to hear this issue and have their input as well. But we try to do our best and try to make the right decisions at times. And if we don't make the right decisions, there's always the option to appeal our decision to the district court. A couple thoughts that I had, and Wes, maybe I could ask you this. I asked the specific question of Mr. Evans if the law was violated, or if if Provo City violated the law in December, and I think that was one of the last questions I asked, and his response was they absolutely did. In December, and my question, I guess, for you is: should the appeal have occurred at that time? Why not make the appeal at that time? I guess your argument is that they didn't have enough notification, the individuals?
I think a couple of things on that. I think the first thing is that they didn't have enough information on what they're looking at. Obviously there's some information, but to have the full, last 5 years of information to be figured out in the matter of 2 weeks. I'm assuming Paul has a job. I know you have a job, I'm just joking, but any citizen, not anymore, okay. So maybe he could have done it for 2 weeks straight, I don't know. But I just think the whole scope of it is so big that it kind of falls without that 2-week window. And also just back to kind of Barbara's point, saying that we're outside of it. If the city did actually, and this is just going off of basis on opinion, but if the city did actually tell Ms. Mehmet that she was outside the jurisdiction because of the 27th, and there's no reason to appeal because you're not going to be able to get it because you're outside of it, but you actually were, that misinformation would actually change it. I mean, it sounds like she was ready to appeal, but that misinformation or maybe lack of understanding of what the situation was, and because we're all citizens, it's kind of hard to figure it out because we're not all Gary McGinn, who's genius at this stuff. He always corrects me on stuff, but he'll probably correct me later tonight.
It's a good point.
But
I guess that's the rub of it. I mean, we've heard information today from a lot of residents, and thank you, by the way. Your candor was much appreciated, as well as your courtesy. We heard that the city wasn't forthright, and the question, I guess, that comes in my mind, maybe Gary could address this issue, is if the city wasn't forthright, that seems to me to be a totally separate issue than what we're dealing with here. Or addressed in a different manner. I mean, as the Board of Adjustments, we've never heard an issue of the city not being forthright, and therefore this continues the time period. I don't know the answer to that. Would you like to address that, Gary?
I believe the answer to that is the clock begins to run at when people are on notice that there's a problem. And usually with building permits, people aren't on notice until construction is begun. And construction began, even if you say, well, it began in December. So even if you say January 1 is when people are on constructive notice. You can talk about the different plans and things like that. But the argument, as I understand it, is the settlement agreement allowed a sign that some people's reading of the ordinance does not allow. Does that make sense? Mm-hmm. And therefore, when construction started, whether the footing's 2 feet or 3 feet or 5 feet or I believe there's even a plan that shows 7 feet at one point. Anyways, it's in violation because it would be higher than the 10 feet from what they're saying in the ordinance, citing that. And so there's a lot of issues around that. I think at the end of the day, the city's legal position is that there is notice, but let's assume that the day after construction started, it was in here. The appeal was made, and we're all here, and it's certainly within the 14 days. I think the city's position is that still wouldn't matter because it's not within your jurisdiction to review a settlement agreement that authorized this to go forward because it's a settlement of a legal dispute between what the interpretation of that ordinance is. Because then that would mean that the city, the mayor's executive powers would be subject to Board of Adjustment review.
So how do they appeal it?
By going to court. By going to district court and saying the city did something illegal in their settlement agreements. Because all settlement agreements that may, in a lawsuit that may, and the city gets sued occasionally over development, and we have, that's just kind of a normal routine thing that happens in the city. Not every day, but we have lawsuits with that. Then that would almost mean that the Board of Adjustment would have to review and approve every settlement agreement in a lawsuit that the city would have dealing with construction.
And I don't know that
I would agree that, again, that what their complaint is about is the settlement agreement and perhaps subsequently a permit that was issued in October for which construction began in December. But
So do we not
But this
follow
board
that?
couldn't review the decision to settle a legal disagreement. There are more ordinances at play than have been mentioned here, but again, I don't think that this is the proper forum to air those grievances over whether or not this is in fact a monument sign, and whether or not the monument sign ordinance applies to it, and whether or not other types of freestanding signs can be built there, and if so, can they be 600 square feet and up to 26 feet in height? Those types of issues, again, we were prepared to litigate them in that case with Dr. Gibby and with Blue Rock Medical LLC, but ultimately determined to resolve those for reasons best known to the mayor and the city council. So ultimately, there were legal disputes. It's not as cut and dry as Mr. Evans would like you to believe, but ultimately they made a decision to resolve it because there was an ambiguity in the ordinance as to how the different parts of the code interplay with each other. And ultimately, it's not the Board of Adjustment's duty to review whether or not they ought to have resolved it that way, or whether or not they had the authority to resolve it that way. That's a district court decision. And if they have standing to challenge that settlement agreement, then they ultimately could sue over that potentially, but that would be the remedy, not going to the Board of Adjustment.
So the permit, we don't have the jurisdiction over a settlement, but a permit that is contrary to the code?
Well, the permit is issued pursuant to that settlement agreement. That's why the city issued it, is because of the settlement agreement. And so the question comes up, does the city have the legal authority to settle a case and then pursuant to that settlement agreement, issue a permit with the in compliance or pursuant to that settlement agreement? And then if you're saying, well, it doesn't comply with the settlement agreement, well, that's an enforcement issue, which is not an issue for the Board of Adjustment. So if there are remedies, and not necessarily saying that I don't believe that there aren't remedies, it's just this isn't the proper forum for any remedies they may be seeking. For the Board of Adjustment to review and approve a settlement agreement. Because if the board can say, no, this building permit doesn't comply with the settlement agreement, you're taking away the power of the executive branch to resolve lawsuits when the very nature of the lawsuit is to resolve a difference of opinion of what the underlying ordinances mean.
And we're a court of appeals in a sense, aren't we, though? So if it breaks city code, then they can appeal to us in that sense.
That's
You're an administrative tribunal that reviews decisions of the city, not, you don't get to review district court cases. That's for the Utah Court of Appeals and the Utah Supreme Court to do.
Yeah, so if this permit had come to us and there was no settlement agreement, and we issued the permit as you see it now, and someone appealed that, absolutely this is the perfect forum and this is where you should go. But that's not what happened. What happened in this case, there was a lawsuit over a disagreement of what the underlying ordinances mean, and the city resolved that in the 4th District Court.
So, but if it breaks our laws in our city, it doesn't matter?
Well, that was what the dispute in court is about, whether what they wanted to do does break our laws.
Well, it was a dispute about that, but the settlement wasn't. It was just to get done with the thing and figure it out, right? Their interpretation of what it was.
It was to resolve the dispute that was pending in court. To say that the Board of Adjustment has jurisdiction to review the resolution of that dispute is to suggest that any legal settlement agreement that resolves a legal dispute in district court is now subject to review in the Board of Adjustment if it involves a Title 14 issue. I don't think that that's what the code says. It's not it wasn't a Title 14 decision or administration or interpretation that Mayor Kaufusi did. It was an executive act to resolve a legal dispute involving the city. And that executive act is not something subject to review by the Board of Adjustment.
Thank you, Gary.
Thanks.
This is an interesting issue. This is a hard issue, too. Very difficult issue. I mean, I liked what was said. One of the presentations said the city must follow their own laws. I wrote that down here because I believe that's exactly true. And I like the presentation about our elected officials and that we need to hold our elected officials accountable for what happens in our city. And that starts likely with the mayor and goes down to the city council and on down the road. However, as citizens, I think we also are required to uphold the law. And what I am torn on is this notice requirement and whether this notice requirement was violated, which then if it's violated, we do not have jurisdiction. And that's what I'm torn on, and I'm somewhat leaning in that direction. And I know Mr. Evans would argue against me on that notice wasn't provided, but I can't get over that December timeframe and the argument by the city that notice is provided at the time construction begins. And I appreciate all of the arguments that were made that we didn't know it was a sign that was going up. We didn't know that. One thing I do know is that as citizens, we are required to follow what's provided. It's not clear to me, but at least that's the way I'm leaning. Is there any further discussion?
I think my only thought is I am seeing it a little bit different than you guys, but based on what Gary just barely talked about, I think that regardless, we don't have the jurisdiction, and if the citizens want to take it up with the court, then that's the direction they probably would go. Or maybe Dave Sewell can work on it or something in the city council. I don't know, but I'm kind of moving towards that with the last statements of Gary that we don't have jurisdiction regardless of the 14 days. I do think that there was some misinformation on that, and that the people of Provo are trying their best to stop something that is against the code and that went above and beyond them. And had they known or had the opportunity to file for the appeal at that time, they would have done it. If they knew all the information, they would have done it, and they would have come to us in the same extent. And then Gary would have said the same thing you just barely said, and maybe we still wouldn't have the jurisdiction that we would hope that we would have. Which again is just misinformation, right, to the citizens who, I mean, Paul just put in, I don't know, maybe 2 full weeks putting that CD together, but to not know or understand if the board has jurisdiction, it comes back to the whole statement why I support that if we did have it, then the 14 days is not a big deal in a lot of ways because of the misinformation and the understanding of the full situation. So, but given the case that we wouldn't have jurisdiction over the settlement anyway, I kind of am leaning towards that.
Would you guys be willing to table it until you fully understand if you do have jurisdiction? Because the city's been somewhat disingenuous in information they've provided to citizens.
So I'm sorry, you're not being picked up by the mic at all, and we'll give you just a few moments to respond if you're. Would you please state your name as well?
Jeff Caffane. Would you guys be willing to table the issue until you fully understand if you do have jurisdiction, outside legal counsel or however you guys go about it? The city's been somewhat disingenuous on the information that they've shared and the willingness they've been doing, grammar requests and so forth, to get the information, filings that don't occur until months after the permit had been issued. So I think before you guys vote that you don't have jurisdiction, would it be possible to get an independent assessment about that?
Thank you. I don't have a good response to that other than I don't know if continuing this benefits any parties. I don't think we have the power as a board to issue some sort of red tag on the project and to be able to stop the project. That authority belongs to Provo City. So I don't think it resolves that issue. It would put you down, it would put Mr. Evans' application down the road another 30, potentially 60 or 90 days. And by that time, the sign is likely going to be complete, would be my guess. I'm not sure it does any good, and at least in my opinion, my issue is the notification time period in that December of when construction began. That's where my hangup lies, and so I don't think I changed my opinion based on that time frame of when construction began. Does anybody have a differing opinion on that?
I concur with you on that.
I
I think that it, what is written is written, and while we would like to do some things differently, we can't go against what is on the books.
Thank you.
And I see it differently, but I think the jurisdiction is not ours for different reasons.
Could I address the jurisdiction issue just a moment? I know this is out of order.
Yeah, well, Mr. Harrison, we'll give you 30 seconds, but this will be the only discussion on jurisdiction.
If you adopt the argument of council, that means that anytime the city enters into a settlement agreement on any city code issue, you have no right to review it. So no matter what it is on a building permit, you will not have a right to consider that, because the city says our settlement agreement opts you out of your function. That's what he said. So the point is, if somebody makes an error in thinking about a code section, and then the city decides to solve the problem not by fighting it, which they should have done, but by settling it, it takes it out of your hands to ever deal with the proper issuance of the permit. That's what they're arguing, that the citizen has no remedy to appeal a permit that's been granted in error.
We agree with you on that. You're absolutely right on that issue, Mr. Harrison. The drawback is that there are other remedies besides coming to the Board of Adjustments to handle issues. Although we would like to call ourselves the end-all be-all, we're not. We are. Mr. Evans, we'll give you 30 seconds to close, and then we'll decide this issue.
The Board of Adjustment can make a determination whether or not the administration has correctly interpreted Provo City Code in carrying out provisions in Title 14. With that in mind, a question that I'll reemphasize, the foundation. A foundation can be built below grade of the sidewalk. The foundation, it does not have to be above, in order to have the right foundation. And again, the question that is before you is, did Provo City Administration correctly interpret that the foundation was not a part of the height of the sign?
Thank you. Thank you. Any further discussion amongst the board members? Would the board like to entertain a motion? You talking to me?
Yep.
Oh. I'll make the motion. Yeah. I'll make the motion that we approve the staff recommendations as found in the staff report to dismiss the appeal of Mr. Paul Evans on the administrative decision regarding the Blue Rock Medical sign located at 3152 North University Avenue. Is there a second?
I'll second.
Is there just any discussion on the motion? All in favor on the motion say yes.
Yes.
Yes. Any opposed?
Yes.
No, 2 in favor, 1 opposed. We have no further business today. Again, thank you for being here today. We appreciate all your comments, and we'll be in recess, so we're adjourned.
trying to